Good morning, everyone. Thank you for your patience as we got started this morning. These are our civil motions for March 30th. I'm going to call your case. Let me know that you are here and let me know if you would like this taken down. Ms. Washington is our court reporter today. If you need an explanation of what takedown means or the cost associated with it, please let me know. I have position 125A 04747 Crown Asset Management LLC versus Brian Mock. And I have that this case has been continued. Is anybody here for that case? I have position 225A 06113 Torres Jones versus Jonathan Broughton Rush Truck Centers of Georgia, National Union Fire Insurance Company of Pittsburgh, and John Doe's 1 through 2.
Good morning, Your Honor. Jeremy Robinson for the plaintiff. Your Honor, I'd like to ask for a continuance. I'm not sure if opposing counsel would be open to such. We are in good faith efforts to resolve this matter, and I think it would save the court some time if we were allowed additional time to try to resolve it.
Your Honor, this is Joe Wiesen on behalf of the defendants. I'm not consenting to the continuance. I want to get this issue finalized and get this motion dispensed with. But we are negotiating in good faith, but I just want to dispense with this issue.
Well, I'll make a motion, Judge, a motion to dismiss with prejudice, and we can dismiss this motion.
It is plaintiff's motion for reconsideration, and you are moving to dismiss your motion for reconsideration with prejudice.
Yes, Your Honor, since we're in good faith and we're close in resolving the matter.
Okay. I will grant your motion.
Thank you, Judge. Thank you for your time.
You all have a good day.
Thanks.
You all are free to go.
Thank you.
All right, position number 323A 04867 Cherie Hall Dunkley as surviving spouse and temporary administrator of the estate of Mark Anthony Dunkley versus Piedmont Henry Hospitals, Emory Healthcare, et al.
Keishan Davis on behalf of the plaintiff, Your Honor, and we're happy to share and take down.
Sharonda Barnes on behalf of Piedmont Henry, and we're agreeable to share with takedowns.
Good morning, Your Honor. Tim Benden and Evan Porter on behalf of Emory Clinic, Emory Healthcare, and 2 providers, and we're happy to share and take down as well.
You said it was Mr. Benden, and who else is here with you?
Evan
Porter. Sorry, I have my Hollywood squares here, and I'm trying to find everybody. And how long do you all anticipate? I know you all have like 5 motions. So.
Your Honor, on behalf of plaintiff, I think all 5 motions combined, we should be good for 30 minutes on our side.
Defendants?
On behalf of Piedmont Henry and the 2 motions that we have, I think 10 minutes is fine for us to respond.
For us, Your Honor, 20 minutes will be fine.
All right, I am going to give you all about 50 minutes total. We'll keep an eye on the time.
Thank you,
but
Your Honor.
I'm very likely going to take this motions or this case last, just so you know if you'll need to turn your computer screens off. Position number 425A 04765 HS Management Company versus Covington Shell.
Good morning, Your Honor. Ryan Robinson on behalf of plaintiff. I don't believe takedown will be necessary. I spoke Friday afternoon to opposing counsel, and if there's any chance we could be placed in a breakout room, I think we might be able to reach a consent order here regarding the payment of rent into the court's registry.
I love that announcement. I am going to place you in a breakout room right now before you change your mind.
Thank
you,
you,
Honor.
Judge.
1 second.
And if you could, my client is here as well. That's if you could include them in the breakout.
Give me your client's name one more time.
It's Nabil Group of companies.
Yes.
And Judge, also my client Nilufar Morium, if you don't mind adding her, please, to our breakout room.
Done. 1 second. All right. Come back with good news, okay?
Yes, Your Honor.
Will do.
All right.
Thanks.
All right. Position number 525A05645, Wells Fargo Bank versus Isaiah Gibson.
Good morning, Your Honor. Chad Simon for Wells Fargo Bank.
Is Isaiah Gibson on the call? Ms. Burton, have you gotten any notices back for Mr. Gibson?
Is that directed towards me, Your Honor?
No, I'm asking Ms. Burton.
Oh,
Just give me one moment, I'll check.
Thank you.
No, I don't show any return notices for Mr. Gibson.
Mr. Simon, hang tight for me just a little bit. I'm gonna finish calling the calendar and Mr. Gibson doesn't show. We'll deal with that case first, okay?
understood. Thank you.
Position number 624A02055, Jennifer Elijah Musa versus Omar Van Putten.
Good morning, Your Honor. Michael Baskin for the plaintiff.
And Mason Baruki for the defendant. I don't think we have discussed takedown prior to this hearing. My client, we're willing to split in the takedown if that's agreeable with Mr. Baskins, but I'll defer to him.
We will. Yeah, we'll share in the takedown. I don't think it's necessary, but yeah, we'll share.
All right, and how long do you all anticipate?
I probably only need 2 to 3 minutes, Judge. Maybe if you have questions, maybe a little bit more, but that should be it.
Same here, Your Honor. I think no more than 2-3 minutes to respond. I think it's clear.
I am going to be really generous and give you all 10 minutes total to argue.
Thanks, Your Honor.
Thank you, Judge.
Feeling generous today.
We'll
All right, position number 725A04420, Fortress Investment Group, CF Ascent Holding LLC versus Yolanda Henderson.
Good morning, Judge. Daniel Green for the plaintiff.
Good morning.
I don't need any formal time. I would just move with what we filed on our pleadings.
Then it's denied, Mr. Green. There's no proof at all whatsoever of what you are asking.
I saw that too, Judge, quite frankly.
Okay,
I understand.
well, then your motion is denied.
Thank you, Judge. May I be excused?
You are free to go. All right, position number 823A05383, April Fenner versus Joseph Harris. And that has been settled, so I do not need hearing on that. All right. Let's start with position number 6. 24A02055, Jennifer Elijah Musa versus Omar Van Putten.
Good morning, Judge. This case is brought before you today on defendant's motion to dismiss under a very specific statute, OCGA 3692-3. It's been long-standing, Judge, that when a local employee commits a tort involving a covered motor vehicle, they're not subject to individual liability. The specific language of the lawsuit, not subject to lawsuit or liability, therefore, and that's been the case since 2002. The cases that were cited by Mr. Baskins, every single one of them, I think, misstates this specific statutory immunity, as all of the cases cited by Mr. Baskins were cases that were given out before this statute was enacted into law. All of them are from the 90s, and the one that was decided after the passage of the statute involves a 1997 motor vehicle accident, also before this statutory immunity was expanded by the passing of the statute. I think that there are several cases after the passing that actually analyze this specific statute that I think are more applicable and go against some of the arguments that Mr. Baskins has made in his brief. Notably in Deloach versus Elliott, this is 289 Georgia 319 is a 2011 case that I think is instructive. There, Mr. Baskins in his brief makes comments about how there's a difference between, being on a police chase with your lights and sirens on versus merely doing a routine patrol that he defines as ministerial. That Deloach case, apologies, the officer was just on a routine patrol. Courts have routinely held that you cannot sue the individual. You have to go after and sue the city. Plaintiffs in this instance did not do that, and therefore dismissal is proper.
Thank you. Mr. Baskin?
Your Honor, we stand behind the cases that are cited, Johnson v. Gonzalez and McLemore, standing for the proposition that if in fact the plaintiff is sued in his individual capacity and not in a official capacity, and he was engaged solely in ministerial duties, functions, the law still permits him to be named as an individual defendant. And that is certainly the case here. The defendant was in the county of Gwinnett County when this accident occurred, returning from a routine, as he says, having a car washed when he carelessly rear-ended the plaintiff's vehicle, causing serious injury. None of these cases that are cited have been reversed to date, and we think they're still very much the law in the state of Georgia, both the Supreme Court and the Court of Appeals decisions.
All right, let me take a look at these cases and I'll issue an order. If you guys want to submit proposed orders, please get them to us by Friday. Get them to Mr. Burnett in Word format. His email address is not on the screen, but he usually has it, but I'm sure you'll have it. If not, he can provide it to you, okay?
Awesome.
Will
Thank
do,
you,
Your
Judge.
Honor. They will be dismissed.
Yes, you are free to go. Thank you for your time today.
Thank you.
Position number 5, 25A05645, Wells Fargo Bank versus Isaiah Gibson. I don't see Mr. Gibson on the call. The notice was not returned. This was, for all intents and purposes, his motion. So I am going to deny the motion.
Thank you, Your Honor. That's all I have
Okay.
for you this morning. May I be excused?
You are free to go.
Thank you.
All right, I see. Um, all right, it looks like my position 4 is still in the breakout room. So we can get started with position 3. I don't want to keep position 4 here for an hour if they have an announcement. So I'm just letting you all know in the Dunkley versus Piedmont et al. Case that if they come back, it may stop you and give them the opportunity to make their announcements.
Yes, Your Honor.
Make sure everybody's back. All right. Again, this is 23A04867, Cherie Dunkley, a surviving spouse and temporary administrator of the estate of Mark Anthony Dunkley versus Piedmont Henry Hospital, Emory Healthcare Inc., DBA Emory University Hospital Midtown, Dr. Andres Patino, Barbara Swatsberg, the Emory Clinic. We have a number of motions. We have Emory defendant's motion to exclude plaintiff's expert Joshua Willis.
Yes.
Plaintiff's, oh no, this is plaintiff's motion for sanctions of spoliation of evidence. Plaintiff's motion to exclude Piedmont's expert, Andy Jagota. Plaintiff's motion to exclude Piedmont experts, David Wilson. Plaintiff's motion to exclude Emory's expert, Tyler Barrett. Am I missing anything?
No, Your Honor. And if I can briefly, I'll just say that there are 5 motions, 3 involving plaintiff in Emory and 2 involving plaintiff in Piedmont. Plaintiffs would suggest taking up the Piedmont motions first. Those are the motions involving Dr. Jagota and Nurse Wilson. And just to be frank, that's because I believe those are fairly straightforward motion to exclude motions. And I think that would probably be the most efficient place to kind of begin before turning to the Emory issues. Of course, we certainly defer to the court's desires, but if anyone else has a suggestion, I think that might be best.
Anybody else have a suggestion?
I have no opinion on it, Your Honor. I'm open to what everybody wants to do.
You guys are going to hang out with me for like an hour today anyway, so it doesn't really matter which order you do. Let's take the Piedmont motions first. My understanding is that you want to take up plaintiff's motion to exclude Piedmont's expert, Andy Jagota. Is that correct?
That is one of our motions, Your Honor. Yes.
Is that the one you want to start with?
That's fine. We either Jagota or Wilson is fine with us, either one.
Your case.
Okay. So thank you, Your Honor. This motion in particular, the plaintiffs come before the court on the motion to exclude. I'm pulling up that brief in particular, Your Honor, just a second. Okay. Your Honor, this is a narrow gatekeeping issue. The question is not whether Dr. Jagota is a qualified emergency physician in general. We certainly would agree that he is. The question is whether Piedmont has shown that he has actual professional knowledge of the nursing standard of care under the specific circumstances at issue here as required by 24/702C2D. The circumstances at issue here are specific. This is not about general emergency department operations. This is about nurse-to-nurse communication during an inter-hospital call, including the transmission of clinical findings, patient history, treatment history, and discharge information from defendant Piedmont Henry to defendant Emory. Piedmont's disclosure of this particular expert went broad. They disclosed Dr. Jagota as someone who would say that Piedmont nursing staff met or exceeded the standard of care, and that no nursing act or omission caused or contributed to Mr. Dunkley's death. That's a sweeping nursing of standard of care opinion regarding the nurses. But when he was deposed and asked about the actual nursing conduct at issue in this case, his testimony collapsed, Your Honor. He was asked whether there were any particular standards he was applying to Nurse Brittany Campbell, serving as the ER nurse at Piedmont Henry, speaking on the telephone with a current treating provider at an outside facility, providing information about the patient's treatment and diagnosis history. His answer was simply, no, I'm not familiar with the standard in that sort of exchange. He was then asked whether the nursing standard for exchanging that type of information with an outside healthcare facility was outside of his area of expertise. His answer was that is correct. And it became even clearer when he was asked whether he was presented or here to offer a standard of care opinion about whether Nurse Campbell met the standard during her participation in the phone call with Nurse Schwartzberg from Emory. And he agreed that he was not. He was then asked whether he had any standard of care opinions as to anyone's participation on that phone call, either Nurse Schwartzberg or Nurse Campbell. And his answer was, no, I do not have a standard of care opinion for either one of them. That should end the inquiry. Georgia law does not permit a witness to offer standard of care opinions simply because he's an accomplished physician or because he worked around nurses. The statute requires actual professional knowledge of the standard of care for that provider under the circumstance at issue. Here, the expert admitted he's not familiar with the standard for the very exchange of information that underlies plaintiff's nursing claims, particularly as it relates to the Piedmont employees. And that's the key point. Piedmont may point to an affidavit that was submitted in response to this motion, but the affidavit, his titles, his supervision of departments, his work in hospitals, or his experience interacting with nurses, none of those clear the defects that matter under the statute. The issue is not whether he has general experience in emergency medicine. The issue is whether he knows the nursing standard governing this kind of interfacility nurse-to-nurse communication. And by his own sworn testimony, he does not. At most, he tries to fall back on a general proposition that healthcare providers should be as accurate as possible when communicating. But that is not an identified nursing standard of care under the circumstances at issue. That is simply a broad professional statement, and that certainly fails to satisfy 24/7 702. And that matters in this case because plaintiff's claims against Piedmont is not in the abstract. These claims are that the nursing staff failed to accurately communicate critical clinical information to Emory, including history and discharge diagnosis, and that communication failure contributed to the failure to recognize a rapidly progressing fatal condition. And that is precisely where Dr. Jagota disclaimed his expertise. Party cannot fill in the gap with medical stature or general hospital leadership. And at the very basic point, that is why this is a gatekeeping issue. If the jury hears a physician say that nursing staff standard of care, despite his admission that he does not know the standard governing the communication at issue, the jury is being asked to accept authority without foundation, and 702 does not permit that. So for those reasons, we ask the court to exclude the testimony from Dr. Jagota regarding Piedmont nursing standard of care, including any opinion that Brittany Campbell or any other Piedmont Henry Hospital nurse met the standard of care, and any opinion that no nursing act or omission caused or contributed to Mr. Dunkley's death. Thank you.
Ms. Barnes?
Yes. Thank you, Your Honor. So to address a couple of things, first and foremost, plaintiffs are trying to limit their criticisms of Piedmont Henry to a communications issue. They're experts. We are far in this case. All of the experts have been deposed, and the criticisms against Piedmont Henry are not just related to communication issues, but are also related to chest pain protocols that are in the hospital, which plaintiffs' counsel did not ask Dr. Jagota any questions about, which he has opinions about and believes that the nurses complied with the standard of care in those respects. Setting that aside as it relates to this communications issue that they are trying to limit their criticisms to, Dr. Jagota is qualified under OCGA 24/7 702 C2A and C2D We've provided his, he was not asked any questions in his deposition regarding his qualifications and supervision of nursing staff, but we've provided an affidavit to the court detailing his CV and his experience in the area of both nursing training and supervision. Importantly, he's been practicing as an ED physician since 1987. He's been medical director of the emergency department for Mount Sinai in developing policies and procedures as it relates to communications between healthcare providers. He was also chair of the emergency department at Mount Sinai. So as it relates to his involvement in not only the development of policies and procedures in the emergency department and supervising nurses as it relates to their communications, we've set forth that educational and training background in his affidavit. What plaintiffs are trying to do is misconstrue his statements in his deposition, and he was very clear that he does not believe if in fact this communication occurred and there was a misstatement by a nurse in the emergency department, he does not believe that to be a standard of care issue. And he testified affirmatively to that. He said, I don't believe this is a standard of care issue. I think that is a nursing communication issue. And if you are trying to construe it to be a standard of care issue, I don't believe it's a violation of the standard of care to give incorrect information on accident in the emergency department, nor do I believe it's gross negligence. That's what he testified to in his deposition. But what he said is that there is a professional standard in the emergency department that all emergency department providers have to comply with. Whether you are an ED physician, whether you are a nurse, whether you are a technician, every provider in the emergency department has a duty to try to be truthful and accurate in the way that they convey information between each other. And that is what he is qualified to testify about, given not only his titles and his accolades, but his actual personal experience in supervising, training nurses and staff in the emergency department, as well as promulgating policies and procedures related to those communications. So we have established both in his affidavit and through his testimony that he is abundantly qualified to give these opinions. They just don't like that he has these accolades and is supportive of the nursing care, and that's strictly what it boils down to. So we believe that this, if they want to ask him about, why he doesn't believe this is a standard of care issue and this is more of a professional judgment and communication issue, that is fodder for cross-examination at trial, but it is an improper motion to exclude, and we ask that it be denied.
Your Honor, just briefly.
60 seconds, Mr. Davis.
Yes, and I just want to be very clear about just a couple of things. First off, there are two lanes that the court has to travel. It's just one happens to come before the other. We're not questioning whether he's, generally speaking, qualified to testify. That's the initial primary hurdle that has to be made. This is about whether he has the actual knowledge to provide the testimony once he's been deemed qualified. He's qualified because he's a doctor in the emergency room department. His experience certainly is not a problem to us. Secondly, I want to be very clear about this. Ms. Barnes is getting her motions mixed up. We're arguing about Dr. Jagota. We'll talk about Nurse Wilson in a second, but Nurse Wilson is the one who testified that if something is done on an accident, it's not the standard of care. That's not an issue in Dr. Jagota's testimony, and it certainly shouldn't be an issue to be considered here. This is just very clear. He was specifically asked, and if everyone wants to stipulate as it relates to the Emory phone call between the two defendants, that the Emory defendants were not acting in a professional capacity, and this is not a professional negligence case, such that the standard of care requirements of an expert, as well as the burden of proof that we have as a professional negligence case, then we'll be fine to admit that this is a simple negligence situation, but it's not. And she even used the word professional when she described what type of discussion this was. The statute is clear, the cases are clear, and you have to be able to say that you understand the standard of care necessary based upon your training and experience, and you're going to apply it appropriately to these facts. Dr. Jagota is unable to do that. And that's all. We're not asking that he be excluded to the extent that he has other opinions that he's qualified to give. But the simple fact is he's not, as it relates to whether any nurse met the standard of care in their participation in this phone call that they both participated in as professional providers for Mr. Dunkley. Thank you.
Your Honor, if I can, it's page 49 of his deposition. I'm not confused on any of the motions that I was quoting directly from Dr. Jagota's deposition testimony, and that's page 49. Thank you, Your Honor.
All right, let's move on to the next motion, which is nurse. It's Nurse Wilson, I believe. Mr. Davis?
Okay. This is plaintiff's motion to exclude Piedmont expert David Wilson, registered nurse, his opinion, particularly his opinions related to the standard of care for any doctor in the case, and his standard of care as it relates to any advanced practice provider in the case. Georgia law could not be clearer. Nurse or medical support staff shall not be competent to testify as to the standard of care of a physician. And there were numerous opinions provided by Mr. Wilson, both as they relate to standard of care and ultimately those that served as the basis for causation opinions that he provided during his deposition. So Mr. Wilson should not be allowed to tell this jury whether Dr. Patino's medical decision-making was appropriate, whether discharge of this patient was appropriate, whether the workup that was performed at Emory was appropriate, whether reliance on information received during a phone call was reasonable, whether additional testing should have been ordered or would have been ordered, or whether a different diagnosis would have changed the ultimate outcome for Mr. Dunkley. Those are physician judgment questions, and they're barred by the statute. Your Honor, the record shows that that is exactly what Nurse Wilson did. When asked whether misinformation played in any role in the outcome, he testified in substance that he believed it was inconsequential. It did not play any way with the patient's outcome, and went further. It could have been an acute versus chronic situation, which is diagnostic in nature, and it would not have changed his disposition. And the patient still would have been discharged, as well as suggesting that he didn't see any other testing that would have been done. That's not nursing. That is physician level disposition, physician level workup opinion, and that is precisely what the statute bars. And it's similar for advanced practice providers like Nurse Schwartzberg. Competency is not determined by what the defense wishes they had limited him to. It is determined by what he's offering and what the jury will hear. If Mr. Wilson, Nurse Wilson, is going to tell a jury that Nurse Schwartzberg's evaluation duties were what she was required to do during her clinical assessment, whether her disposition should have changed or whether she had an independent duty that breaks causation, those are advanced practice provider medical decisions. And under 24/7/702, the witness must have the required licensure and actively practice relevant to the position of the specialty at issue. He's never practiced as an advanced practice provider. Let's see, we'll move to the issue about causation. Georgia law requires causation testimony in medical negligence cases to be stated in terms of reasonable medical probability or reasonable medical certainty, not mere possibility. The courts evaluate non-physician causation testimony on a case-by-case basis, and the analysis turns to whether the opinion stays within the witness's area of expertise. All experts must meet 24/7/702, sufficient fact, data, reliable methodology, and reliable application. Speculative, conclusory opinions are inadmissible. Piedmont tries to label Wilson's opinions as factual causation. And to be quite frank, Your Honor, I was kind of thrown off making it through the brief as they went back and forth between their phrase factual causation and what was really going on in the case. But the court should look at the substance and not the labels. And the admissibility inquiry remains tethered to the witness's expertise. When an expert says this information would not have changed the provider's workup, would not have changed testing, would not have changed disposition, or would not have changed outcome, that is not nursing workflow testimony, Your Honor. That is medical decision-making, proximate cause, and ultimate outcome analysis. And those opinions are required medical diagnosis and medical judgment, and Georgia law does not allow Piedmont to backdoor those through a registered nurse. It's been well settled and held that no expert can testify outside the limits of his area of expertise, and Georgia law treats opinions about medical diagnosis as falling outside the limits of a non-physician's expertise. This case involves a death outcome. Causation is not that it probably did not matter or it wouldn't have changed anything. Georgia law requires causation to be expressed as reasonable medical probability or reasonable medical certainty. Even if Piedmont claims that Wilson was only describing what happened next, his conclusions are still proximate cause conclusions tied to medical judgment and medical outcome. He is not qualified to express it in terms because his analysis depends on medical diagnosis, medical decisions, which are outside of his nursing scope. And for those reasons, we ask the court to exclude Wilson's causation opinions and outcome opinions. That's all we have for that issue, Your Honor.
Ms. Barnes?
Yes, Your Honor, first, just so we're clear, and I think Your Honor is well aware of the communication issue in this case, but just for context of our argument and a response, Your Honor, it is alleged in this case that the nurse at Piedmont Henry gave incorrect information to the staff at Emory that therefore led them to a misdiagnosis in the case and ultimately to Mr. Dunkley's death. Nurse Wilson did not give any opinions regarding the cause of death, what could have been done related to the death, anything related to that. And so first and foremost, plaintiff's counsel said multiple times that there is some bright line rule in the state of Georgia that nurses cannot give causation opinions, and there indeed is not, which is why one is not cited in his brief. The causation opinion that he is giving in this case is that based on the factual testimony that has been given by the healthcare providers at Emory, they did their own independent investigation and assessment of Mr. Dunkley when he presented and determined what they believe was on their differential diagnosis and discharged him accordingly. And so this was a factual statement that was made by the healthcare providers at Emory. And so what he was saying in his testimony was that even if there was misinformation that was given at Piedmont, that did not cause or did not contribute to the evaluation that happened at Emory, because the Emory providers have testified they did their own independent investigation and decision-making regarding this patient. So he was not giving any sort of causation testimony or any standard of care testimony for that matter in terms of what the nurses should have done, because indeed if he had done that, I'm sure Emory would have filed a motion saying that he was an expert against them. And so he did not give any expert opinions as to what could or should have been done by the healthcare providers at Emory. Rather, he was saying factually, based on the testimony that has been offered in this case, whatever happened at Piedmont did not impact the care and treatment that happened at Emory. He was well within his rights to say that. There is no law in Georgia that bars him from giving any factual causation testimony based on his review of the deposition testimonies in this case, and that is what his opinions were based on. Again, he did not give any opinions regarding the ultimate cause of death, which we would agree is a medical causation opinion that has to be given by a physician. I just think that this motion should be denied based on those grounds. So thank you, Your Honor. If you have any questions, happy to answer them.
And again, Your Honor, the motion is that he not be allowed to make pretty specific opinions. If she wants to consent that he's not qualified, I mean, as a very baseline, he's just not qualified to make standard of care opinions about a doctor or a nurse. Whether she believes he made them in deposition or not, of course, our brief cites multiple pieces of deposition testimony. But, Your Honor, this whole dispute about what he was simply referring to based on his review of the depositions, the court has his deposition. He didn't even review all of the depositions in this case. And more particularly, plaintiffs have cited multiple times Dr. Patino, when deposed, asked, why did you diagnose Mr. Dunkley as having chronic kidney failure? He specifically said, because we were told that over the telephone. So all this stuff about independent, did an independent evaluation and came up with their own stuff. Dr. Patino was very clear. He diagnosed chronic kidney failure because he was told that over the telephone. That's in his deposition. And so, you know, that kind of, all of this, he was just talking about what he read, that kind of falls apart. Simply put, he's not qualified to provide the limited scope of testimony with which we're trying to exclude. You know, in the alternative, if the court were of the position that the court wanted to allow him to testify at all, plaintiffs request a strict limiting order. He may testify only about nursing tasks within an RN scope, not about medical diagnosis, not medical decision-making, not what a physician or advanced practice provider would have done, not proximate cause, not outcome, or any other conclusion framed as no effect or no change on the ultimate outcome, that being the death of Mr. Dunkley. Thank you.
If y'all want to submit.
Your Honor, if I may, just really quickly, there was a statement just made just now, the court would allow him to testify at all. It is not before this court whether or not he is qualified to testify regarding nursing standard of care. This is the first time I'm hearing that he is now trying to say that he should not be allowed to testify at all. There is no motion to that.
And
Okay,
I'm
well,
not saying
I don't think
Okay.
that's on the table. So
and I'm not saying that. I haven't asked that. Yeah.
Okay, well, you just said, should the court even decide he's allowed to testify at all? That's not before the court, so.
Well, the court is not construing his motion that way, so
Thank you.
you don't have to worry about that, Ms. Barnes. If you have any proposed orders, please get them to Mr. Burnett by Friday, in Word format, please, okay? On those
Thank you.
motions. All right,
Yes,
let's
ma'am.
turn over to the Emory defendant. Since we are dealing with expert testimony, let's go ahead and address the expert motions first.
Good morning, Your Honor.
Good morning, Mr. Porter. Go ahead.
So this instant motion concerns whether plaintiff's cardiology expert, Dr. Joshua Willis, is qualified to provide expert testimony as to the medical care and treatment provided to Mr. Dunkley by the emergency department providers, Dr. Andres Patino and nurse practitioner Barbara Schwartzberg at Emory University Hospital Midtown on October 14th, 2018. As we know, OCGA 24-7-702 requires an expert to have practiced in the area of specialty for at least 3 of the last 5 years. Georgia law further provides that a physician may testify outside of his own specialty so long as his expertise equips him to address the condition at issue as alleged by the plaintiff. In other words, they have to have sufficient experience in diagnosing the condition, performing the procedure, or rendering the treatment which is alleged to have been performed or rendered negligently by the defendants. Further provided by Georgia law, in order to determine the area of practice or specialty in which the opinion is to be given, courts look to the allegations of plaintiff's complaint. So if we look to the allegations of the plaintiff's complaint in this case, specifically at the expert affidavit of Dr. Joshua Hellman filed with the complaint, Dr. Hellman alleges that the Emory providers departed from the standard of care by discharging Mr. Dunkley home from Emory University Hospital Midtown when he exhibited signs and symptoms of severe anemia with significantly abnormal blood work and complications related to sickle cell crisis. So based off the allegations of plaintiff's complaint, the area of practice or specialty in which Dr. Willis is to be providing his opinion in this case is the diagnosis and treatment of severe anemia and sickle cell crisis in an emergency department setting. In other words, for Dr. Willis to be qualified to give these opinions, he must have for at least 3 of the last 5 years been regularly engaged in the active practice of diagnosing severe anemia or complications related to sickle cell crisis, or in rendering the treatment for severe anemia or sickle cell crisis. And it is our position, Your Honor, that simply put, Dr. Willis does not have the requisite recent education or practice experience in diagnosing severe anemia or sickle cell crisis in an emergency department setting to offer his medical expert opinions in this case. Among other things, in the three of the last 5 years, Dr. Willis testified that his treatment of patients in the emergency department was limited to cardiac consultations, and he would see the patient only after the emergency medicine team performed their initial examination and intake of the patient, and if and only if the emergency medicine team believed that a cardiology consultation was necessary. And importantly, Your Honor, none of the experts in this case have testified that Mr. Dunkley required a cardiology consultation while in the emergency department at Emory University Hospital Midtown on October 14th, 2018. Dr. Willis additionally testified that when patients presented to the emergency department complaining of sickle cell crisis or hemolytic anemia, he was only consulted if the patient was also experiencing cardiac issues. And if he was consulted to treat a patient who presents to the emergency department complaining of sickle cell crisis or hemolytic anemia, he was not consulted to treat the sickle cell crisis or hemolytic anemia, but he was only consulted to treat any cardiac issues that the patient may have also been suffering. And lastly, Your Honor, Dr. Willis testified that his treatment of patients with sickle cell crisis and hemolytic anemia in the emergency department most often involved and was limited to advising the emergency medicine team on whether the patient should continue on Eliquis, which is a prescription blood thinner. Additionally, Dr. Willis has never practiced emergency medicine. He is not board certified in emergency medicine. He has never published any articles or given any talks in sickle cell crisis or hemolytic conditions. And he has never provided expert medical opinions on a case similar to the issues in this case. And those are all things that Dr. Willis testified to in his deposition. So for all of those reasons, Your Honor, we believe Dr. Willis does not meet the requirements of OCGA 24-7702 and relevant case law to provide standard of care testimony as to the emergency department providers, in this case at Emory University Hospital Midtown. And we respectfully request that the court grant our motion to exclude Dr. Willis as an expert.
Thank you. Mr. Davis?
Yes, Your Honor. I believe the Emory is completely confusing the issues in this case. And I will just start by saying again, 24-7702 is a gatekeeping issue. The question is not whether Dr. Willis is an emergency room physician. The question is whether in the area of practice or specialty in which the opinion is to be given, he has regularly engaged in the active practice with sufficient frequency to have an appropriate knowledge in performing the procedure, diagnosing the condition, or rendering treatment alleged to have been performed negligently. That's Graham, Mikoya. That's very basic and standard law, Your Honor. These cases establish that a physician may testify outside of his own specialty so long as his experience equips him to address the condition or the acted issue. Dr. Willis's practice regularly requires him to interpret blood work, identify anemia and hemolysis, and determine when admission and further evaluation is required. He's testified about that throughout his deposition, and the sites are in our brief. Those are precisely the duties Emory providers failed to meet when confronted with Mr. Dunkley's labs. Defendants are trying to redefine the area as the entire universe of emergency medicine, diagnosing and treating severe anemia and sickle cell crisis in emergency room department setting. That framing is overbroad and is strategic. Uh, Anderson explains that the court does not define the area by a convenient label or a hyper-specific task divorced from the pleadings and the allegations made throughout the discovery process. The inquiry focuses on the actual treatment or diagnostic task alleged to have been negligently rendered and whether the witness has recent sufficient experience in that lane. That is exactly what's happening here. Even Emory's own standard of care defendant, expert Tyler Barrett, conceded he understands the allegations that Emory failed to perform in this case. And Your Honor, I just asked the court to simply read page 69 of their defendant, their expert's deposition. It specifically asks, now, you understand the allegations as they relate to Dr. Patino and North Schwartzberg as Emory defendants are that they failed to reasonably respond to the risk associated with abnormal lab results. You understand that through your review of this case to be an allegation made. Is that correct? Their expert. Yes, that's an allegation. You understand that it's alleged that the failure resulted in missing evolving anemia and related conditions that ultimately resulted in Mr. Dunkley's death. You understand that to be an allegation, right? I understand that to be an allegation. And that they failed to reasonably respond to clinical symptoms like abnormal vital signs. You understand that to be an allegation. And their own expert says, I understand that to be an allegation. And that's very clear because Emory refuses to acknowledge those as particular allegations in this case. And those fit directly in line with Dr. Willis's practice and training. A cardiologist, as he testified, routinely interprets CBCs and CMP abnormalities, recognizes severe anemia and hemolysis patterns, and understands the physiologic risk those abnormalities creates, and knows when the objective data requires urgent evaluation and escalation. We're not asking the court to take on faith that plaintiffs' other experts, including plaintiffs' emergency expert, Dr. Levy, have already testified about the standard of care of Emory providers, particularly related again to abnormal lab data, particularly related again to reliance on independent outside information when Emory's own charts contain information with which diagnostic opinions, medical decisions should have been made on. Your Honor, these are explicit guardrails, and the court can enforce them. Dr. Willis is being used on recognition and response to abnormal labs, not as a substitute ER specialist on emergency department logistics. Plaintiff has emergency medical physician experts who will offer ER standard of care related to ER workflow, escalation protocols in the ER, and emergency department specific operation. Dr. Willis's standard of care opinion is confined to the diagnostic significance of objective labs, what critical diagnostic questions those labs required to be answered, including basic anemia and hemolysis evaluations such as a reticulocyte count, and why those objective findings demand escalation and further evaluation. And he's testified that he does that in his own practice. He does that in when asked to come to an emergency room. That's it. That's all we're asking him to opine about, particularly related to standard of care. He can opine about what reviewing CBCs and CMP mean for any other doctor that regularly reviews CMPs and CBCs, and those acts only. On causation, I'm not sure if there's a if defendants are still pressing forward. I don't think it was discussed in the oral argument, but I do think it was mentioned in the motion. Dr. Willis's testimony is anchored in an objective endpoint analysis about how we get from the cardio issues evidenced in the death certificate and the issues that he experienced at the hospital. And he provides a causal link between each condition and the failures that have been prescribed by not only Dr. Willis, but the specific ER failures that are described by plaintiffs' other standard of care experts. So the court has an easily ruling in this case, particularly as it relates to Dr. Willis. Dr. Willis should be allowed to testify about the diagnostic lab lane and the physician emergency medicine physicians handling as it relates to the diagnostic labs in this case and what those mean and what any, as he testified, reading these CBC and CMP, those are third-year medical student. That's third-year medical student task, one that any doctor regularly does and one that any doctor that regularly involves the exercise of dealing with CMPs and CBCs would and should have understood. So we're asking that Dr. Willis, specifically as it relates to standard of care, be allowed to provide standard of care opinions as to what any doctor who reviews a CBC or a CMP, like the ones confronted to Dr. Patino in the emergency room department, would or should have done. Thank you.
Mr. Porter, any response?
Your Honor, I would just say that we believe that the description of the area of practice or specialty at issue here as just interpreting abnormal blood work is overbroad. And again, looking specifically at the allegations of plaintiff's complaint, and Georgia law establishes that that's where you get the area of practice or specialty at issue. Plaintiff's own expert alleges that the ME defendants were negligent in failing to recognize and discharging Mr. Dunkley home in light of his signs and symptoms of severe anemia and complications related to sickle cell crisis. So again, this is not just simply about interpretation of abnormal blood work, but more so in treating and recognizing severe anemia and sickle cell crisis in the emergency department, which again, as I mentioned earlier, Dr. Willis has a large lack of experience in that area. Thank you.
Well, Your Honor, and just briefly, to the extent, the law first says that in an affidavit or a complaint, we're only required to list one allegation of negligence. It's not required that it contain the entire breadth of issues that come out through discovery, come out through reviewing further medical records, talking to medical providers, whatever is produced during discovery. We certainly have a right to amend or certainly have a right to press forward on whatever issues come out through discovery. In this particular case, discovery, as I've already shown through their expert, discovery produced multiple and numerous violations that were clearly alleged. And to the extent that defense wants to simply harp in on the complaint itself, I just asked the court to go look at count 2 of the complaint itself. The count 2 alleges Emory breached the standard of care by discharging Mr. Dunkley from Emory University Hospital, Midtown, in light of various lab abnormalities. So it's in the complaint, it's in the affidavit, and it certainly was fleshed out throughout discovery as understood by even Emory's very own standard of care defense expert. Thank you.
All right. Thank you both. Let's turn over to, we have 2 motions left. We have the spoliation and then
There's an expert motion, Your Honor, and a spoliation motion.
Yes, I want to hear the expert motion first.
Okay. Your Honor, again, this is a narrow gatekeeping motion. This motion is not about whether Dr. Barrett is an accomplished emergency room physician. He is. The question is whether defendants have met the technical statutory requirement that allows a physician to offer nursing standard of care opinions in the first place, and they have not. And to be clear, we are not asking that there be a full sale exclusion of Dr. Barrett. This is particularly related to his opinions regarding the standard of care as they relate to Nurse Schwartzberg. The statute draws a bright line. It expressly addresses nurses, nurse practitioners, and certified registered nurse anesthetists, and it permits a physician to testify about their standard of care only if the physician supervised, taught, or instructed them for 3 of the 5 years prior. This is not a merits analysis. This is a threshold qualification rule. The court must decide first, only if the witness gets through the gate does the court ever reach the substance of their opinion. Here, the relevant statutory window is October 13th through October 2013 through October 2018. Defendants do not identify concrete facts showing that during that period, Dr. Barrett actually taught, supervised, or instructed nurses or nurse practitioners in the way the statute requires. What they offer instead is routine collaboration. They say he worked closely with nurse practitioners. They say he oversaw patients with them. They point to the normal teamwork of an emergency room department and try to relabel that as statutory supervision. But Georgia appellate courts have already rejected that move. In Penley, the Court of Appeals affirmed exclusion where the physician's involvement with nurses amounted to ordinary clinical interaction rather than qualifying supervision. And that matters because the record here, read fairly and in full, shows the same thing. Defendants rely on a fragment from page 223 of Dr. Barrett's deposition where he answers nurse practitioners. But once the question is clarified, outside of routine clinical collaboration, he disavows any actual supervisory role over nurses or advanced practice providers in the sense defendants now claim. Their argument depends on isolating a snippet or ignoring the clarification that followed in his deposition. The court should look at the exchange as whole and not the few words lifted out of context. Or versus SSC Atlanta Operating supports this position. The physician had substantial expertise in his own field, described routine interactions with nurses as a part of normal practice, and had even lectured nurses. The court still held that was not enough where he had not recently supervised nurses. So OR directly answers defendants' attempt to elevate everyday clinical contact into subsection D supervision. It simply doesn't work.
What is the site for that case?
The site for OR is 360 Georgia App 702. It's a 2001 case, 2021 case, Your Honor.
360 Georgia App 702?
Yes, ma'am.
Okay.
Occasional teaching exposure is not supervision. Your Honor, also Smaha versus Medical Center of Georgia, 368 Georgia App 299. The court required the proponent to show how and when during the statutory period the physician actually supervised, taught, or instructed the relevant providers. General statements, administrative roles, committee work, and broad experience, again, were decided not to be enough. The burden is on the proponent to show qualifying experience with specifics, not labels, and that is exactly what's missing here. Defendants try to get around that by arguing that nurse practitioners in the emergency room department perform tasks similar to those of emergency physicians. They evaluate patients, they order tests, they review results. They participate in diagnosing and disposition. Even if all of that is true, it does not help. In fact, it proves why subsection D exists. The General Assembly obviously understood that advanced practice providers may work in overlapping clinical spaces with physicians, yet it still lists nurse practitioners separately and still requires proof that physician supervised, taught, instructed them in 3 of the 5 years before the physician may be allowed to testify about their standard of care. So similarity of function is not the test. Overlapping in duties is not the test. Statutory qualification is specific, and that's the test. Then there's this affidavit defendant submitted after the deposition and after this motion exposed them to the problem. But the affidavit does not cure the defect. It uses conclusory words like regularly supervised without supplying the kind of concrete details SMAHA requires. It does not identify the specific supervisory acts, the frequency, or the actual teaching or instructions that would have shown qualifying experience. So even taking at face value, it adds labels and not substance, and that's not enough. So this really comes down to a simple point. The statute requires proof, teaching, and instruction. The defendants have not made that showing. Dr. Barrett was specifically asked throughout his deposition, and I believe we have in our brief, we have cutouts of the deposition questions, and it's very clear he has not supervised nurses, nurse practitioners in the relevant statutory period. He even testified that during that 5-year period, the only supervisory interaction he had was administrative in nature. He testified that he works at Vanderbilt Medical School, and there's a separate and distinct nursing school at Vanderbilt. And so they have their own line of supervisory authority over the nurses, of which Dr. Schwartzberg, they have their own supervisory line over the nurses in that department. As such, he's never had any clinical supervision over nurses. He specifically talked about this collaborative approach that has routinely been held to be insufficient in Georgia cases. He was asked directly, Your Honor, and he answered directly. He has not supervised nurses in a clinical setting in the relevant time period. And as such, his opinion specifically related to nursing standard of care must be excluded. Thank you.
Good morning, Your Honor.
Good morning, Mr. Bendon. Go ahead.
Thank you. We believe that the combined testimony of Dr. Barrett, both in the deposition and the affidavit that was submitted, supply the necessary factual basis for the court to deny this motion. Dr. Barrett is qualified to give testimony regarding the standard of care to be provided by a nurse practitioner in an emergency department setting under OCGA section 24-7-702, subsection C2, capital letter D. There's a lot in there, Your Honor, but under that very subsection D, it says, notwithstanding any other provision of this code section, an expert who is a physician, and as a result of having during at least 3 of the last 5 years, immediately preceding the time of the act or omission is alleged to have occurred, supervised, taught, or instructed nurses, nurse practitioners, and it goes on, okay? And so what you'll see when Your Honor reads the testimony of Dr. Barrett, first of all, the deposition, and I would just invite Your Honor to look at pages, and I think both parties would probably agree with this, 221 through roughly 229 of the deposition, where there's a lot of discussion in that about his supervision of nurses, which should not be confused with nurse practitioners. We're not offering Dr. Barrett to testify, and he was never offered to testify about nurses. And a lot of the testimony cited in the plaintiff's brief relates to bedside nurses, RNs, that don't have the APP designation. And of course, there is a fundamental difference between those two providers. A nurse cannot diagnose, cannot order treatments, cannot order diagnostic tests. On the other hand, a nurse practitioner is much more like an ER physician, a provider, and may diagnose and may order diagnostic tests and may order treatments and may direct the disposition of the patient, whether they're to be discharged or not, is fully within the scope of the license of the nurse practitioner. And Dr. Barrett makes clear that he supervises nurses in the clinical setting, nurse practitioners, excuse me, in the clinical setting, providing care. And a lot of the questions that are and answers that are placed in the plaintiff's brief deal with his supervision of nurses, and he readily concedes, I'm not giving standard of care testimony about nurses, but I am about nurse practitioners. Now, I will agree with you, and he says on page 223, it says, what nurses do you supervise? And he says, nurse practitioners. And he says, I supervise nurse practitioners and physician's assistants in our department as we're seeing patients. The only thing that isn't supplied in the deposition that is added through the affidavit is that he does that between October 13th, 2013 and October 2018. And he says, I regularly supervise nurse practitioners. That's all the statute requires him to say. That's it. The affidavit in and of itself, paragraph 9, is sufficient to meet our burden under the law to have him testify as an expert on the standard of care for nurse practitioners. Now, there is one passage, Your Honor, and I want to be clear about this, and he referred to this on page 3 of his affidavit. He is also listed as an administrative director for the APPs from 2017 to 2021. That is to be distinguished from his clinical role. And he says in that capacity only, he was also an administrative supervisor. But he makes clear in the combination of his deposition testimony and the affidavit that he supervises APPs, nurse practitioners, in a clinical setting, providing emergency medicine care to patients regularly between 2013 and 2018. That's all we have, Your Honor.
We hear from Mr. Davis. Any response?
Yeah, I just asked the court to go and take a look at the complete section of the discussion, because there is bedside nursing questions, and then there are questions specifically about nurse practitioners which follow. And he's very clear that outside of working with nurse practitioners and seeing patients, he does not supervise them or oversee them. And he's very clear about that. And that's not enough. There are, and when the court looks at the cases, you'll see that there are expectations about specifics to provide a foundation of understanding about what actually went on, whether this was collaborative medicine or whether you're supervising the clinical practice of nursing. And you'll see what he testified to is he sees patients along with nurse practitioners and physicians assistants in the emergency room department, similar to the cases that I've provided. You'll see that, as a matter of fact, that's the exact same thing that was attempted to be relied upon in the cases that I've provided you. The only other thing that I would like to add, Your Honor, is the attempts to separate out nurses and nurse practitioners. Your Honor, the statute is pretty clear. Nurses, certified registered nurse anesthetists, and nurse practitioners, that's the group of individuals that are the same. An emergency room doctor is the other individual. It's not emergency room doctors and nurse practitioners, and then over here you have simple bedside nurses. No matter what kind of nurse it is, unless it's a nurse with a medical degree. A doctor doesn't have the ability to testify unless they prove these things. So similarity of duties and responsibilities, that's a red herring in the sense that is asking the court to simply ignore what the statute itself says in black and white. Nurses, nurse practitioners, which are advanced practice providers, and certified registered nurses, they're all viewed the same for the application purposes of 24/7 702C Big D. And so to the extent that she's a nurse practitioner, it doesn't relieve him of any of the gatekeeping statutory responsibilities, and they failed to provide it. They're relying on a very generic use of terms, and I think the court will find the cases that I've provided easily leading to a conclusion that they failed to meet the burden of establishing that the expert who they've proffered is proper in providing nurse practitioner standard of care opinions. Thank you.
Briefly, Your Honor.
60 seconds, Mr. Bendon.
Okay, I'll use less than that, Your Honor. To the extent, I don't think, I think Mr. Davis may perceive that there's some conflict or contradiction between the deposition testimony and the affidavit. I don't think that's accurate, but if that were true, that's not a basis to exclude him, because there's evidence in the record before Your Honor that he supervised nurse practitioners during the requisite time period. And that's all we have to show. And to exclude him based upon anything else would be error. So, and then I want to point out that the statute says supervised, taught, or instructed, and it says nurses, nurse practitioners, and various other things, or other personnel. So he doesn't have to show that he was qualified or supervised all of those people or all of those specialties. So it can be isolated to one. Thank you, Your Honor.
Thank you. All right, let me put a quick pause on this case. I see that position. Position 425A04765, that you all are back. Do you have an announcement for me?
Yes, Judge. On behalf of HS Management, we have reached very general terms regarding a consent order between the parties, and we are asking the court, and Tim, please correct me if this is incorrect. We're asking the court if we could get a week from today to basically submit the terms of, or submit that consent order for the court's consideration. Basically, briefly summarize, there's a slight dispute over the amount of taxes, unpaid property taxes owed from 2024, but we're in very broad terms talking about the defendants paying the past due rent into the court's registry, and then unopposing any sort of motion by the plaintiff to draw down on those proceeds, and then the tenant paying rent monthly starting, say, May 1st into the court's registry, then with the plaintiff being able to draw down on those monthly amounts as they are paid.
And that's correct, Judge. In principle, we just need to check on. There was an amount that the landlord has stated that they paid for 2024 property taxes. We weren't able to confirm all of that amount today on our side, and we would just like some time to do that. And we would ask the court if we could have that, a week to submit a consent order on these issues.
That's fine. What I will do is I am going to place this case in my next motions calendar. Nikia, can you help me out with that date?
Then we May 6th at 1 p.m.
And I do that because I don't like to have cases sort of hanging with no place to go. So I will place that on the May 6th motions calendar with the understanding that you all are going to get a consent order to me that is going to move this motion in the next week, okay?
Yes, Your Honor.
And then
Thank you,
we'll
Your Honor.
remove you from that calendar and move you to whatever calendar you need to go to next, okay?
All right.
That sounds great.
Thank you, Judge.
You all are free to go?
I would-
All right.
Thank
Thank
you.
you, Your Honor.
Have a great day.
All right, I think on position 3, we only have one motion left, and it's a motion, the spoliation motion. Give me a couple of minutes and we'll hear that motion, okay?
Ms. Barnes, nice to see you.
You too.
How you been?
Hanging in there. Lots of trials.
Right. Congratulations on your last one. And I don't, actually, it may not have been your last one now, but your last, the one that I know of is in DeKalb.
Oh, yeah. Piedmont, yeah.
Yeah.
Thank you.
Welcome.
It was an interesting one. It was fun. Have you heard about the default and all of that in there?
About the what? I'm sorry.
The default?
No.
Yeah, that's what made it sort of crazy. Heather got pulled in because the employer of the nurse practitioners never filed an answer. And so they made an appearance on the day of trial. They contacted Heather over the weekend because it was like a defunct Emergenet group. And they were like, we need you to show up at trial on Monday. So she showed up at trial. So even though they never employed the providers, they were in default.
Well, there's not a lot to do, is there?
No, but because we got a defense verdict, Judge Alexander held that holding them to default would be an inconsistent verdict. So she ended up letting them out, but it was it provided all of these crazy wrinkles in the entire case. Cause like, could they sit at the table during phase one? Could they not? It's like a whole thing since they can't contest liability. So she held that they couldn't sit at the table. So they had to like sit in the back.
Really? Well, you can still contest damages if you're in default.
Right. But that was phase two.
Well, that's true. In phase one, you don't have really any active role.
Yeah, so they sat. So during phase one, they sat in the back. Yeah, we never got to phase two.
You can technically challenge, even if you're in default, you can challenge under some of the case law that I've found some causation arguments that don't make sense. So in other words, well, that.
Yeah, no, that was what was said. I mean, it was a lot of moving pieces and a very bizarre case for sure.
Wow.
Yeah.
Who else
was like, could that jury still stay and hear damages awards? It was just like, I felt like I was in law school all over again.
Oh, interesting.
Yeah, and then you heard they got the Piedmont one last week, they got a mistrial on Friday.
Yeah, why was that?
Expert opinions that were previously ruled out, plaintiff's counsel elicited.
Who?
Yeah. So that one was with Hall, and I think was Chronic down there. Nathan Chronic and Page and Taylor had Showa. Yeah, so they were supposed to be in Cobb for 2 weeks.
Mm-hmm.
All right, are we ready to proceed with the motion, plaintiff's motion for sanctions for spoliation of evidence?
Yes, Your Honor.
All right, go ahead.
We're here on plaintiff's motion for spoliation sanctions. This is not a technical discovery dispute. It goes to whether this case will be or even probably can be tried on a fair record, because the native EMR audit trail data for the key time period is missing. And that is data that is the only objective time-stamped evidence of who accessed the chart, when it was reviewed, what was reviewed, and when that happened. Georgia appellate courts define spoliation as the destruction or failure to preserve evidence relevant to contemplated or pending litigation. That definition is stated in multiple cases. They're cited in our brief. There's a 5-factor framework that the court applies in deciding sanctions. That's prejudice, ability to cure, practical importance, good or bad faith, and the potential for abuse. Defendants emphasize correctly that severe sanctions are reserved for exceptional cases, and we believe that that's what we have here. Plaintiffs, we're not asking for a default judgment or anything, but we are asking for tailored curative relief that fits the prejudice in this case. Emery suggests that the data never existed, and I think that's one of the most important points that we need to deal with as an initial point of clarification. The fact of the matter is that the data existed. Emery even admits that the system worked in a fashion that when a provider accessed the chart, generated audit events are then written into what's called their Millennium system. And then the audit events are transferred for and I'll just use my phrasing, long-term keeping over into P2 Sentinel servers. In that same section of their brief, Emory admits that during 2018 migration, that the data should have been flowing to the P2 Sentinel long-term kind of saving space was halted. They suggested it was halted for a 2-week period in 2018 that just happens to correspond with when our client was seen at Emory. And Emory then draws a semantic conclusion that because the events were not ingested in the P2 Sentinel long-term keeping database, that the logs never existed, Your Honor. But that's backwards. The Emory's own narrative concedes the point that for the matter of spoliation, the audit events were generated during the encounter itself, including during the admission. Then the pipeline that preserved them is what failed. Calling that never existed is simply a relabeling of a preservation failure. In Emory's own P2 loss memo, which is attached as an exhibit, which was provided to us in discovery when we requested audit data, it's very telling. I can't pull it up, but the exhibit is very clear. The court has it, as I said before. The event happens. It's placed into their Millennium system. It's held in Millennium. Millennium then sends it over into a separate outside database location to be preserved. That link is what broke. Millennium worked fine. It was all in Millennium. It just wasn't sent over to P2 Sentinel. And that's not our issue. But to characterize that as it never existed, that's disingenuous at best. Applying the Phillips factors, the 5 factors for the court to consider, prejudice exists when spoliation deprives the non-spoliating party of the most direct evidence of facts in dispute. That is exactly what the audit trail is in a modern EMR case. Without it, plaintiffs cannot objectively establish the timing of review, access, sequence of clinical decision-making, and cannot meaningfully test testimony about what providers claim they knew at the critical moments as it relates to Mr. Dunkley's care and treatment in Emory. And, Your Honor, that's very important in this case because we have a case where we have multiple providers seeing our client at Emory. They're saying during deposition testimony, they don't know if or when they reviewed diagnostic testing, which, as we've already discussed, reviewing and appropriately appreciating the diagnostic testing goes to the heart of our case. These are providers who are saying they don't know when they reviewed it throughout the care and treatment timeline. They don't know if they reviewed it prior to making discharge decisions. They don't know if they reviewed it prior to having discussions with other healthcare providers. And they don't know if they reviewed it to hold it consistent with communications they were having with outside hospitals. All of that would have been time-stamped in the log. It was in Millennium. They're suggesting that 2 weeks never made it over to P2 Cerner, but it was in Millennium. It was in Millennium. And the fact of the matter is we can't answer any of those questions now. And neither could they. Secondly, the curability. This prejudice can't be cured. Emory's own memo says the data is not recoverable and cannot be recreated. Later logs starting on December 21st, 2018 do not cure the losses that they've identified during that 2-week period. As far as the practical importance, the missing window is the core encounter. This is not collateral. The audit trail is the only objective metadata that ties user identity and timestamp to access an activity in the chart. Finally, good faith or bad faith, the court cannot calibrate the sanction on culpability. But even accepting Emery's claim that the loss was not intentional, Georgia law does not make spoliation relief dependent upon proving a smoking gun of intentionality. Here the record reflects, at a minimum, negligent failures during migration, disabled monitoring, and a halt to the flow of the audit data, followed by an attempt to redefine the loss as non-existence. Fifth, potential for abuse. Defendants are positioned to defend with narratives about what was reviewed and when, while the only neutral mechanism to test those narratives is missing. This is precisely the type of imbalance the spoliation doctor seeks to prevent. I can't even imagine where we would be if all that has to happen is the metadata become missing, and we just rely on a defendant's suggestion about the nature of their motive, and then the plaintiff be left to deal with the mess that the wreck has caused. It's almost, I can't think of a more restricted position or handcuffed position to be in trying to simply answer very basic questions about what happened in this case. We have to remember that the responsibility to have these audit logs in the form and fashion that was requested, Your Honor, this is the type of stuff that is required under federal statute. They have a federal statutory responsibility to keep all of this audit data specifically for situations where an occurrence like this might happen. We have submitted a motion to have an outside individual perform an inspection. During that inspection, we learned a number of things, and you will see the affidavit that is attached to our motion from Dr. Arias. You will learn that Dr. Arias is clear that the information existed at some point. It did exist. What happens now is it's unavailable. So it did exist. It was not migrated into where they've decided to keep this information for long-term preservation. And so he answered the existence question. The second thing, and one more important thing that's in his affidavit, is that at some point in time, and not some point in time, I think it was 2022, 2020, they went from Millennium to a system called Epic. And what happened is they made a decision that they were going to take 2 years worth of metadata that still existed in Millennium and put that in Epic. And his affidavit shows that he learned that during this migration period, the reason Mr. Dunkley wasn't migrated was because they didn't migrate individuals with whatever information was in Millennium. They didn't migrate individuals that were already deceased. And he was a deceased patient at this point in time. That's very important because at a minimum, at that point in time, we had already asked for whatever EMR information you had to be provided and or preserved. So at a minimum, at that point in time, if there was something that could have been salvaged or saved, they certainly shouldn't have been applying the dead patient rule to Mr. Dunkley. Not only was he an individual that had died, he had a lawsuit pending, and he had a lawsuit pending at the time. That's enough. And they specifically said that whatever was in Millennium at the time was not transferred to Epic, this new system, because he was a patient that had died. And so, Your Honor, for these reasons and the reasons contained in the affidavit that Dr. Arias submitted attached to our motion, we ask that the court find spoliation in this case. Our prayers for relief are that court's indulgence, that a finding of spoliation as to the missing audit trail, a permissive adverse inference, a rebuttable presumption, instruction calibrated to what the court finds as it relates to defendant's culpability, preclusion of any argument that the EMR is complete, accurate, or unaltered, given the missing audit verification, permission for the plaintiffs to explain the loss and its significance to the jury. And Your Honor, I think this part is most important, well, not most important, but of equal importance, that fees and costs caused by this spoliation fight, including the forensic inspection that the court allowed plaintiff's expert to have with Emory, be bore on the defendants, particularly Emory in this case. And finally, I just want to make a quick mention about an affidavit that was filed, I think it was last Thursday, by Mr. Decker. And I just want to mention very briefly a few things. Mr. Decker's affidavit does not solve the problem in this case. Particularly, he admits Millennium actually generated the audit data, and that is in his affidavit, and that it was supposed to be automatically extracted into P2 Sentinel, and that for the critical period, that period, it was not collected in P2 Sentinel. When he tries to explain why he does so in extremely secondhand terms, it doesn't sound as if he has any personal knowledge. He uses phrases like, "it is my understanding," and I think that clearly shows that this is not from direct documented personal knowledge. And I think that alone makes his affidavit extremely weak. But Dr. Harris' affidavit, when compared to the one from Mr. Decker, it makes a larger point how it explains that Emory represented that only 2 years of data was migrated from Millennium to Epic, that all Millennium patient data should have been archived in Harmony, which is what they use now instead of P2 Sentinel. We know Harmony contains nothing helpful, particularly as it relates to the metadata that was missing or is missing, and instead it should reside somewhere. Even their notice says it should reside somewhere. We just don't know where it is. And so for these reasons, we simply ask that the court appreciate the magnitude of what's missing here, and that the court find spoliation and grant the relief that I've just mentioned. Thank you.
Thank you, Your Honor. And of course, I have the pleasure of representing Emory Healthcare, Dr. Patino, nurse practitioner, Schwartzberg, and the Emory Clinic. Obviously, we oppose this motion. Now, I don't want anything that I say here today to trivialize what our duty is under federal law. We acknowledge up front that an audit trail with the detail that's required by federal law was not created for Mr. Dunkley's visit on October 14th, 2018, along with probably hundreds, if not thousands, of other patients between October 4th and October 19th of 2018. But we disagree with any insinuation that it was malicious or intentional or in bad faith or even negligent in any way. We disagree that there was a failure to preserve evidence at a time when Emory was on notice of a potential lawsuit. And we wholeheartedly disagree with the insinuation that the plaintiff has been prejudiced or disadvantaged by the loss of this audit trail data, and I'll get into that. So really, we don't believe they're entitled to any sanction at all. I want to touch on the legal framework. I think our briefs probably overlap a great deal. I don't know that there seems to be much substantial disagreement between the parties about what the law says. I will add on that there, as Mr. Davis mentioned, there is a 5-factor test, but there's also a threshold issue that the court must decide before getting to that five-factor test. And I'd cite, Your Honor, and I think it's in our brief, the Marta versus Tyler case, 360 Georgia Appeals 710, which is a really good description of the legal framework. And it basically tells, Your Honor, that you must first determine whether spoliation has occurred before you get to the five-factor test. And to determine whether spoliation has occurred, you have to determine, one, that the information or evidence in question must have existed and been in control of the party. That's referenced in the Treadwell case in our brief. And then, in addition to it having existed and been in the control of the party, that the duty to preserve that only arises when the party has actual or constructive knowledge of the potential for litigation. And so that duty only arises at that point. And then once the court makes that determination about spoliation, then the court must determine what sanctions, if any, are justified. The cases that we've cited do indicate that the loss of relevant evidence due to mere negligence normally should result in less sanctions, if any at all. We don't even think there was any negligence here. And then, of course, there's the five-factor test. I think Mr. Davis outlined it fairly succinctly, whether the affected party was prejudiced, whether the prejudice can be cured, the practical importance of the evidence, whether the party that lost the evidence acted in good faith or in bad faith, and the potential for abuse if a sanction is not given. So the remedy for a rebuttable presumption or adverse inference instruction is a severe sanction. And that is only to be given in exceptional cases, as the Phillips versus Harmon and Creek House Seafood Grill case cited in our brief, Your Honor, state. And those exceptional circumstances are generally only in those cases in which the party lost or destroyed material evidence intentionally in bad faith and thereby prejudiced the opposing party in an incurable way. So it has to be both. There's also a request for some evidence, some preclusion remedy, some evidence preclusion remedy. And there are cases that deal with that I think that are not cited in our brief that really stand for the proposition that where there has been deliberate concealment of evidence, then the court can preclude some testimony. I'd cite, Your Honor, to the Resurgence versus Elliott case, 303 Georgia 580, the Anglin versus Smith case, 346 Georgia Appeals 456, for the proposition that there really has to be deliberate acts that would justify the preclusion remedy that's been requested here. I think it's very important for the court to understand this principle. The court may not punish parties who are not the subject of the motion for sanctions. So when you read plaintiff's brief, it talks about in some way, and it's kind of indirect, punishing Dr. Patino or punishing Ms. Schwartzberg in some way, and an adverse inference instruction and some issue preclusion would prejudice Dr. Patino and Ms. Schwartzberg, and they are not parties to this motion. And so I want to be clear that that's a problem in this case too. I want to bring up another issue that may not be clear to the court either. The motion as it's framed is written as a motion to sanction the hospital, Emory University Hospital, Midtown. The fact of the matter is Emory University Hospital Midtown is a separate legal entity and it's not a defendant in this case. Emory Healthcare is the employer of the nursing staff and the employer of Ms. Schwartzberg, and that's why it's in the case. Emory Clinic is the employer of Dr. Patino, and that's why it's in this case. The hospital is not actually a named defendant. We have put plaintiff on notice of this multiple times in discovery responses and in the answer that Emory Healthcare is not, quote unquote, doing business as Emory University Midtown Hospital. And so I don't know that they've even brought the motion. The motion is proper against anyone other than the hospital, which would have the duty to maintain the audit log under federal law. So I want to touch on, Your Honor, having given you the framework of the law, I want to touch on the chronological sequence.
Mr. Bendon, can you go back for a second? I just want to get a clear understanding of what you just said because I think it's important.
Sure.
You said that the motion for sanctions is as to Emory University Hospital?
Well, that's the way it's framed. It says, and I don't want to, in the style, the defendant is listed as Emory Healthcare, Inc., DBA Emory University Hospital Midtown. Okay? That is not actually a correct DBA for Emory Healthcare. There's a separate corporate entity that is the licensee and the operator of Emory University Hospital Midtown.
So what you're saying is that Emory University Healthcare was not the employer of the nurse.
No, it is the employer of the nurse.
Okay.
It's not the licensee of Emory University Hospital Midtown. That is a separate corporate entity under the Emory umbrella. I want to let that out there. Don't want to in any way suggest that it's not under the Emory umbrella. Hopefully that clarified that.
I just wanted to make sure that I had a clear understanding of the players.
And we have repeatedly said in discovery responses and in our answer in this case, Emory Healthcare is not doing business as Emory University Midtown Hospital. And now, and if you read the motion, plaintiff's motion for sanctions, to impose sanctions against defendant Emory University Hospital Midtown, I don't think Emory University Hospital Midtown is actually a defendant in this case, quite frankly. But
because that's a separate legal entity.
Because it's a separate legal entity.
Okay.
So I want to talk to you a little bit, Your Honor, about the facts that I think are important to the legal framework that I've outlined for you. So we know the Carrot issue took place October 14th, 2018. Mr. Dunkley was seen and evaluated by Ms. Schwartzberg and Dr. Patino. He was discharged that same day. Unfortunately, he passed away the following day. Regarding the loss of audit data, Emory used a third-party EMR system created by a company called Cerner. It's called Cerner Millennia. And then the audit data that's required under federal law was to be created and captured in another server, as Mr. Davis said, the P2 Sentinel server. And I think that's also under the Cerner umbrella, but honestly, I join in Mr. Davis when these IT people start talking about some of these issues, my eyes glaze over. I don't really understand it, and I don't know that my language is always consistent with what an IT person would say, but here's the way I understand it. And I will tell you that the purpose of the affidavit of Mr. Decker that was submitted last week was to sort of put in English what the memo that's attached as an exhibit to both parties' pleadings. It's a 3-page memo that was created after this thing was discovered. that really is in total IT speak and is very difficult to follow, and the affidavit is simply to try to put it into straight English. But during the time window between October 4th and October 19th, audit data in the detail required under federal law was not captured. And this was unknown to Emory, and the failure to capture the audit data was felt to be related to troubleshooting that had been done by Cerner, which is both in that report I referenced and in Mr. Decker's affidavit, that inadvertently disabled alerts which would have warned of the problem. And so that all happened back in October 4th, 2018. At the time, the providers were providing care, and those types of data logs were not created way back at that time. And honestly, according to the evidence, could never be recreated. Emory's first possible notice of this claim, to fill in the facts, couldn't have come any earlier until September 25th, 2019, almost a year later. And at that time, plaintiff's counsel sent a letter and release to Emory Midtown Hospital for medical records. Now, it didn't say we're investigating a claim against Emory. It just said, hey, send us your medical records. It could be an auto wreck. It could be anything, so we don't. Obviously, no one really knows, but that is certainly the only first possible notice. There's been no other evidence submitted to the court that Emory, anytime before that, should have been on notice of a potential claim that the Dunkley family had. And the lawsuit wasn't brought until October 15th of 2020, when Emory was served with that October 20 of 2020. And we think that's actually when Emory had first notice of the claim. And this was well after the data had already been uncaptured and was uncapturable, was unrecreatable, if you will.
What was that date, Mr. Brendan?
I'm sorry, which date?
The 2020 date that you gave me?
Oh, it was when the plaintiff filed the lawsuit. So, which would have been, it was filed October 15th, 2020, and served on October 20th, 2020. And obviously that would be undisputed notice of the plaintiff having a claim, and undisputed time when the duty would arise to preserve evidence if it existed. And so medical records were produced to the plaintiff. And the medical records that were produced to the plaintiff do contain who saw Mr. Dunkley. They contain information about what each provider did and the notes that they made. They include test results. They include narrative notes. They include what the providers documented. And that's all indisputable. There's an 85-page medical record of everything that happened during Mr. Dunkley's visit on October 14th, 2018. So the lawsuit was initiated in October of 2020. The plaintiff attached an affidavit of an expert, Dr. Hellman. He had reviewed all of those experts, and without an audit trail, he was able to set out standard of care testimony in an affidavit fashion against Dr. Patino and Ms. Schwartzberg. No difficulty whatsoever prosecuting the case, understanding the timeline, understanding what they knew or should have known, and taking his case forward. The first request for audit data was in discovery with the lawsuit, and on December 18th, 2020, we informed the plaintiff of the loss of the audit trail data, that it did not exist, it couldn't be recreated, and we provided the memo that Your Honor has heard about, the 3-page IT memo, about how that occurred, and then the case just continued on. discovery commenced, and as Your Honor may know, there was a dismissal and a renewal action filed. But over the course of 5 years with the original action and the renewal action, 5 employees or 5 people at Emory University Midtown Hospital, employees of Emory Healthcare or the clinic, Dr. Patino, Nurse Robson, Nurse Colquitt, Dr. Anna Deal, and of course, Ms. Schwartzberg, they've all been deposed at length over the entries that are in their records and what they knew and what they didn't know and when. We've had numerous depositions of experts. Discovery proceeded in this case just like any other medical malpractice case without the benefit of any sort of native audit trail. There was no protest, no statement, nothing for 5 years about the absence of this audit data trail impairs us in the prosecution of our case. Germane to some representations that have been made to Your Honor, the plaintiff requested in 2024 a different type of document that can be culled from the Cerner Millennia records, and that's what are called version notes. And we provided 5 versions of the provider note that contains the work of Ms. Schwartzberg and Dr. Patino to the plaintiff, which does in fact contain their entries in the record. You can track through those 5 versions what information was added at what point. Again, we never heard anything about this audit trail up until 2025. So in 2025, the plaintiff first again brought up this audit trail issue and sought inspection of the EMR system as well as the P2 Sentinel servers. And the plaintiff's expert and their team came and did their analysis of Cerner Millennium and the P2 Sentinel servers. That was done in May 2025 and August 2025. And essentially, they came to the same conclusion that we had told them back in December of 2020. And that is that the audit trail data cannot be recreated from what we have. It's because it was never ingested into the P2 server and could not be recreated even then. And so this motion for sanctions followed. Now, there's one thing that was brought up that I take issue with because it wasn't in the brief and it wasn't argued in the brief. And that is the idea that Emory's migration or transfer to another EMR system in some way was the event that happened that caused us to be unable to capture this audit trail data. And I will tell Your Honor that happened in 2022. If that were true, if it could still be captured in October of 2022 or sometime in 2021, and it was the migration from Cerner to Epic that actually caused the loss of the data, then you would see that in Mr. Harris's affidavit. And you would see that in the report created by Emory. And there is no actual evidence to support that data was retrievable anytime between October 2020 and 2022 when Emory transferred its EMR from Cerner to Epic. Okay. And the representation has been made that that's in Mr. Harris's deposition. It's not. That it was still retrievable when they did that migration. So anyway, this motion was filed of course, in October of 2025, and I want to walk Your Honor through the application of the facts, and I'll do it quickly, I'm sorry. First of all, there has been no spoliation. The information or materials must have existed and been in control of the party. As I said, in looking at the Marta versus Tyler case that I cited and the Treadwell case, we had to have had it in our possession. Here, the evidence submitted by us indicates that the data in question was never created, never preserved. The Emory report and the Decker affidavit support that. And the plaintiff actually went out in 2025 to try to disprove that point and to try to find that the data evidence, the data trail existed, and in fact confirmed what Emory said, that it could not be it could not be recreated. So logically, Emory can't spoliate something that was never actually created. It was actually lost during the time that the patient was actually being seen. And Emory certainly couldn't have been on notice of a claim then. And again, the duty to preserve evidence arises when the party has notice of a claim. That's when the duty would be triggered. The earliest arguable date would be September 25th, 2019, but no one said they had the claim. Really, the only realistic date is October 20, 2020, when Emory was served with the lawsuit. So there can be no spoliation here, and that's the threshold determination the court needs to be had, or that the court needs to make, because we never controlled or possessed the audit log in the form that it was to be created, and we certainly never had it when by the time we were on notice of the claim 2 years later. So that can't be spoliation. Obviously, I still want to address the factors that are in the case, because if the court disagrees with me for some reason, then I need to at least address those issues, and I'll try to do that quickly, Your Honor. So the Treadwell case and the Creek House Seafood Grill versus Privatis case cited in our briefs set up those 5 factors. And I want to talk about a little bit about some of those, and then I'll wind up. So the one I want to talk about first is the 4th, whether we acted in good faith or in bad faith. And I don't think there's any evidence here that Emory acted in bad faith. In fact, the affidavit we submitted, the report indicates that it was Cerner who accidentally disabled an alert that would have brought this to the attention of Emory, Cerner, everybody else involved. And we didn't know about it at the time. We only discovered it afterwards. So there's no neglect on Emory's part. There's certainly no bad faith. There's certainly no intentional failure to create this evidence. And in that situation, in the absence of any bad faith or bad act by us, the plaintiff can't get the remedies they're asking for, because as the case law we've discussed talked about, even if you found it's only in the exceptional cases where there's bad behavior by somebody. And so those remedies are not really available, because even if there was negligence, which I think is very thin here, that would not result in or authorize any severe sanction, such as an adverse inference instruction or evidentiary preclusion or anything like that. So it should only be given in exceptional cases where there's been bad faith. So I want to touch on the issue of prejudice and the practical importance of the evidence. That's factors 1 and 3 in the cases. And we do have a fundamental disagreement with the plaintiff about what an audit trail is and what it does and what it really captures. And I don't think it really captures anywhere near what is argued in the brief and to a lesser extent during the oral argument, Your Honor. The regulations talk about the audit data being created to detect unauthorized access, maintain data integrity, protect patient privacy, and to show in some way how documents, if they've been changed, have been changed. There is nothing in the regulations that talks about the use of or the function of an audit data trail to help with the forensic investigation of what people knew and when they knew it, the timing of review, sequence of clinical decision making. Those phrases do not appear in the regulations. The timing of when somebody looked at a specific lab result, that information is not in the audit trail. It's not that specific. It's not required to be that detailed. What a provider knew at a given time, the audit trail does not read people's minds. It does not tell anybody what a provider knew at any specific given time. And so it doesn't do a lot of the things that the plaintiff is protesting that they can't recreate because it's not designed to do that. The regulations don't say they do that, and they don't do it as a matter of fact. I want Your Honor to look. So when all of the data collection restarted because of whatever happened, after October 19th, 2018, there is data log information in the form required by the federal government that was captured and has been produced to the plaintiff. And if Your Honor wants to look at an exemplar of that, I would invite Your Honor to do so. It's Exhibit F to our response. And Your Honor will see that a data trail in the form it's supposed to be created provides essentially none of the information that the plaintiff is saying is missing. And so to act like it's some magic bullet that would timestamp every action taken by every person and every provider is simply not accurate. That is not what it does, and it's not a forensic tool like that. And it is required, and we are required to the audit data would show information regarding who accesses the chart and if changes are made to something. But we have, through another vehicle, we have provided that to the plaintiff with their request by giving them the 5 versions report that they can track how the doctor and the providers, the nurse practitioner's note was changed over time. And it's got the times on there. And you can see where information is added. And anybody who wants to go through and track what information was changed or added at any point in time by the providers, that can actually be tracked. And so it in fact is not lost. It's provided through another vehicle. And so the elimination of the audit trail has not deprived the plaintiff in any way of any evidence or deprived them of an ability to fully prosecute their case. I would ask Your Honor that rather than rely on plaintiff's counsel's representations that this impacts their ability to prosecute their case, that Your Honor ask plaintiff's counsel why none of his 6 experts who talk about standard of care ever mention an audit trail, even asked for an audit trail, have submitted an affidavit in support of this motion that says, man, if I only had this audit trail, I'd be able to figure this case out and help the plaintiff with their case. I mean, that is not actually accurate, or it's not actually even close to what's true, because the plaintiff's experts can look at the records, look at what they knew, look at what they should have known, and the plaintiff can fully prosecute their case based upon their expert testimony. In 42 years of doing this, I have never had an expert who relied upon an audit trail to tell them whether they could support or defend a medical malpractice case. So I think Your Honor needs to take that assertion with a grain of salt. There's a suggestion that the audit trail would show the defendant's knowledge at critical moments. There's no way an audit trail will do that. There is a suggestion that the audit log will tell them at what time Dr. Patino reviewed specific tests. The audit trail doesn't tell them that. And there's no federal regulation that requires an audit trail to have that level of detail. They suggested in their brief that an audit trail would tell them what portions of the record a provider reviewed. It doesn't tell them that. And again, I invite Your Honor to look at Exhibit F and see if it does that, because it doesn't do that. They've argued that the core dispute is whether the defendants knew of and responded appropriately to laboratory results. Again, the audit log doesn't tell you when they saw a lab result, nor does this really deprive them of the opportunity to make the arguments they've made. The lab data is incorporated into several of the versions of the notes, so it's clear that Ms. Schwartzberg and Dr. Patino had the opportunity to review it. They've been asked about whether they did or didn't, and they've given answers to those questions. So it was there. The audit log in no way would help the plaintiff answer any of these questions, and it doesn't certainly impair the plaintiff's ability to advance their case. Touching briefly on factor 2, whether the data is recapturable or it's gone, it's whether the loss is curable. The loss of one form of audit data cannot be recaptured, but we can, because of the other reports, the other versions report, see what changes were made in the record, and so that part of it can be followed. I think the only thing that I can tell, and Your Honor may have the question, what could be in the audit trail that they don't know? The only thing I can think of is if somebody whose name doesn't appear in the medical record accessed the log on the 14th, that may show up, or that should show up. So the last factor is the potential for abuse if sanctions are not imposed. And you know, the only argument the plaintiff makes on that factor is that, you know, Dr. Patino and Ms. Schwartzberg would be permitted to rely on their own self-serving recollections. Well, Dr. Patino and Ms. Schwartzberg are entitled as a matter of law to rely upon their own recollections, whether self-serving or not. And that should not be punished in any way by this audit trail issue, because they are not legally responsible for maintaining the audit trail. That is not a duty that federal law imposes upon them. And so the court, if the court is going to contemplate any punishment of someone certainly should make it craft it in a way where it does not punish Dr. Patino or Ms. Schwartzberg or Emory Clinic, or I would argue even Emory Healthcare. So, because they're not the party that's supposed to be maintaining the audit log data. There's a similar argument raised in the brief about outside hospital records that came from Piedmont Hospital, and I think the same analysis applies. There's no evidence that we actually had it in our possession. There's no evidence that it was in our possession at the time that we were on notice of the claim on October 2020. So we can't have spoliated that. And there's really not any evidence that the plaintiff would be prejudiced because we know what records from Piedmont Hospital have been given to Mr. Dunkley, and so it is actually recreatable. We don't believe the plaintiff's request for the expenses related to their investigation to determine if our representations were true or not. Their investigation established that what we said was true, that the data trail could not be recreated. They're in no better position after having spent $27,000 than they would have been if they had just filed a motion for spoliation sanctions in December 26th of 2020 or 2021 or 2022. And so they didn't need to spend that to be in a position to file this motion. Why should we have to pay because they disbelieved us when we told them we can't recreate it? We shouldn't have to pay for their expert. So we shouldn't have to pay any other expenses or fees. I'm happy to answer any questions Your Honor may have.
Thank you, Mr. Benden. Mr. Davis, any response?
Yes, Your Honor. Kind of went around the world, so I'll try my best to, be a bit pointed, but I want to start with a couple of just general and basic suggestions. And the first thing is I think it's very important for the court to understand that there are all kind of practical uses for audit trail information. And there's one thing I also want to do that I kind of want to address at the outset of responding, and that's that defendants, ever since this refile case began, and it's been in a couple of responses, and the last time we had oral arguments, it was brought up, and then the initial basis, it sounds that for Mr. Benden's argument, takes into account time and procedural posture. And so I think it's important. I just want to state on the record that defendants continue to invoke the timing of plaintiff's dismissal and refiling as if plaintiff's use of the renewal statute should somehow count against her, and it shouldn't. 9261 expressly permits a refiling of the statute. That's plaintiff's legal right, and I just want to ask that the court not use it against her. It was her legal right. That's not a legal argument. That's an insinuation. If the defendant believes that somehow something egregious as it relates to the renewal statute was done, then they need to file something suggesting that. But it's been mentioned in filings, arguments on multiple times, the fact that she refiled this case. And so I want to start with that. Secondly,
Your Honor, that's not a basis for my response, just to put Mr. Davis at ease. So that's not a factual reason to deny the motion.
Okay. Thank you, Mr. Benden. Secondly, I want to go into a couple of things a couple of suggestions that were made. And the first of which is the suggestion that basically the only thing that can be gleaned from an audit report is whether someone made changes and that we've been provided with documents to show subsequent changes in the record. While we have been provided that, I will suggest to you, Your Honor, that that is patently false. And Mr. Benden knows that. And I'm going to give, he suggested you taking a look at Exhibit F, but I'm going to give you a better practical example about what you can learn in the way of material information, material facts in a case, particularly this case. This is a case where one of the underlying disputes is about whether or not there was even a phone call between the two facilities. We have one nurse saying the phone call happened. We have another nurse saying the phone call never happened. We have one person who puts it in a narrative report at Emory Hospital. It exists nowhere in the record at Piedmont Henry. That dispute still is made between the parties about whether this phone call ever even took place. The individual that's alleged to have participated in the phone call at Piedmont Henry was not even on duty at the time our client was there. He went to Piedmont Henry on the 13th. He was released on the morning of the 14th. He went to Emory on the morning, later in the morning of the 14th. That's what happened in this case. There was a phone call alleged to have occurred later on that morning between the two hospitals where this incorrect information was supplied. It's very important because no one wanted to give on this phone call issue. So we got the audit information from Piedmont Henry. And, I don't know what Mr. Benden expects in audit information. He usually sees, but I'll tell you what we learned from the audit information. We learned exactly who entered Mr. Dunkley's charge after he left the hospital. And then we used the audit information to determine the individual who went in his chart was in fact the individual alleged to have made the phone call. And then we were able to see exactly where she went in his file when she was in the chart, all from the audit information. So the suggestion that the effectiveness of the audit information is what was and wasn't changed, that may be one traditional use to determine when medical providers have altered and changed records. But trust me, in this case, this is not about an altered document situation. We have a case where we have Dr. Patino on deposition. He's unable to tell whether he even saw the patient after tests were performed. He's unable to say so. Now, he has notes in the record. There are other individuals' notes in the record. He's unable to say whether he went in the record after that point in time for review. He discharged this gentleman 5 hours after arriving at the hospital. He's unable to say whether he saw him, whether he reviewed his medical chart, whether he took a look at the diagnostic tests, and whether he considered any of this prior to giving an order to discharge our client. There's no argument that can be made that this information generally is contained in the audit records. It's certainly the kind of information that was in Piedmont's audit record. And you certainly can't suggest that if we're able to answer that question, that doesn't go to the culpability of Dr. Patino in particular, and certainly Nurse Schwartzberg in general as a co-provider of our client at the time in question. I do want to just make one quick mention that Georgia is substance over nomenclature and emotion. The motion, the caption of the motion is not controlling. The court looks at the substance and function of the filings, not the title of the parties or the title of the motion the parties chose to place on a motion. The question is what relief the motion actually seeks and whether it gave fair notice, not what it's called. In this particular, you have Mr. Benden, and I think ultimately the fact that when asked by the court, he used the phrase, well, they're all under the Emory umbrella. That's the real issue. The Emory umbrella received a motion. The Emory umbrella knew they had a responsibility to maintain audit information. And at one point he says, well, it's not like we had a duty. Well, you did have a duty. It's federal statutory in nature. So you certainly had a duty.
Mr. Davis, I'm going to pause you for just one
Yes.
second, and I'll be
Yes.
right back. Okay, give me just one.
Okay.
All right, Mr. Davis, sorry about that. Go ahead.
Thank you, Your Honor. Your Honor, in this particular case, it is imperative for us to be able to answer what Dr. Patino knew at certain points when he was making decisions. And I'll give you one very important example. Dr. Patino testified that he decided to diagnose our client with chronic kidney failure as a result of a phone call that was received from an outside healthcare facility, that being Piedmont. At the same time, Dr. Patino agreed that he had a responsibility, a duty to review the complete blood count, this CBC for our client, which would have showed that he had thrombocytopenia, severe biliremia, and that he was anemic. He agreed that he had a responsibility to review that. He could not testify that he reviewed those records for sure prior to discharging our client. That would be shown in an audit trail. Just as Mr. Benden suggested, the purpose of an audit trail is to determine unauthorized access. You have to look at it from the reverse angle. It's used to determine unauthorized access because it shows who had access. That's what we need to do. Now, for an individual to suggest that, and I will answer what he suggested that you ask me. For him to suggest that you ask me, why haven't we produced affidavits from our experts to suggest that they can't make an opinion on this case absent receipt of the audit trail information? Well, Your Honor, the truth of the matter is that's because, as Dr. Willis suggested, on the standard of care issue, specifically limited to an appreciation of the CBC results, that's third year medical student stuff. He didn't need an audit trail to determine whether or not a third year medical student could have appreciated what was shown on those results. But what it does, that's why he didn't need an affidavit. And that's why the other experts didn't need an affidavit. That's why his expert didn't need an affidavit. But it is important when we have the medical providers at issue in this case telling you they don't know what they saw or what they read when they made material decisions about this case. That goes to their credibility. I can't even question these individuals' credibility about the things they say they saw because I don't have an audit trail to show when they went in the records. So I can't question when they say they saw something. I have to accept their opinion, their memory about what they say they did see, what they didn't see, and then they just get to float out there when something gets really, really questionable. The I don't know about whether they actually entered the record at a point in time. We have a case where the CBC results are clearly defined at the time that they were resulted and entered into the record. And no one can tell me when or if you entered the record after those results became available. No one's able to say it, and I just have to deal with it. That's material information on this case, regardless of whether any of our experts, any of our physician experts, whether ER, cardiology, other advanced practice providers, it doesn't matter what they say, they individually need it. That's material to the case because it goes to credibility at a minimum. And, you know, for now, I haven't been practicing 42 years, but what I can tell you is that in the last 26, I've never heard anyone question the relative need or use of an audit trail. And that's what I've heard here today. Based on Mr. Benden, why does anyone need an audit trail? Unless you're accusing someone of changing records, it's of zero importance. And I'm telling you, that's just not the case because I can show you in this particular case, it's answered the question that I know for a fact. Brittany Campbell at Piedmont Hospital entered our client's records while he was sitting in Emory University Hospital Midtown and looked at his records. At the exact same time that Nurse Schwartzberg said she was talking, and in her record, she put she was talking to Nurse Brittany. And I was able to confirm that in the audit trail, even though Nurse Brittany Campbell said that it didn't happen. And I would like to make those same confirmations about important points in time when Nurse Schwartzberg made the decision to go along with Dr. Patino's decision to diagnose my client with chronic kidney failure when we all know he didn't have it. And the reason that Dr. Patino said he diagnosed him with chronic kidney failure was simply because he was told over the telephone. If he testifies that I made a diagnosing decision based on what I was told over the telephone, I think it's very important for me to know whether he went into the record after diagnostic tests were performed in order to weigh what he was told over the telephone with what was available to be seen at the time. I need to know that. And the fact that we had to send someone over in 2025 and we requested our audit trail well before then. We requested supplementation before 2025 of the audit trail. We had emails back and forth that were ignored by Emory on multiple occasions related to this audit trail. And then we ultimately were forced to file the motion with the court. And be clear, our motion was not filed in order to disprove anything that they said. Our motion was filed in order to have firm footing and grounding to understand, one, whether it ever existed. And if you take a look at the P2 loss report and you take a look at Dr. Harris's affidavit, that's probably the most important thing that they established, is that it did exist. And that there were different points in time when there was additional information that was sent from one system to another. And it did happen that during the investigation, it was learned that specific to Mr. Dunkley, there was a decision made that certain information well after this lawsuit was filed was not migrated from one system to another, specifically because he was a dead patient. I don't know what that information was. You don't know what that information was. And the truth of the matter is, Mr. Benden will never know what that information was. But it is hurtful to our case. it is hurtful to our case if that happened in 2022, as he just acknowledged, regardless of the fact that the failure to have the original migration happened in 2018. And one final thing I want to mention about this whole why they keep information. There are multiple indicators throughout federal statute, and I haven't had an opportunity to look this up, but I believe it even says it on what they've sent over to us, that the whole point in keeping information is, of course, to, as he suggested, unauthorized access to determine that type of information. But it's also because there's always, that's why they have the number of lawyers that they have, in-house and outside counsel, because they always know that as it relates to the healthcare services provided, they always know that there's a foreseeable lawsuit, particularly coming about the care and services that are rendered to patient. One, and two, they know the most important and the most important, I'll just say the most important piece of information that the parties rely on are going to come from the health records, and then whatever information can be provided to support the reliability of such. In this particular case, we've shown that from the testimony of Schwartzberg, Patino, and nurse, what's that? Schwartzberg and Patino in particular, we've shown that the testimony is scant at best. It's certainly of a nature that they can't provide any definitive answers on any of the material information related to how, when, and what they consider to make a treatment or discharge decision for our client. Your Honor, I never thought that this would turn into a discussion about the relative value of audit trails. I never thought this was going to go there. But the truth of the matter is we should not be forced to rely not on what they do remember, but the fact is that we have to be cast the shadows of what they don't remember in this case, particularly when it's material to the issues that will be placed before a jury. And, Your Honor, at this point, we simply believe the evidence shows that, and the use of the spoliation vehicle by the court is not one that requires intent, bad faith. That only goes to the severity of the sanctions. Our motion has a number of sanctions in it. We believe that the court should go all the way up to the very top, but certainly 2, 3, 4, maybe if the court decides to use only 2 of them. That only goes to severity and not whether sanctions are appropriate. So we believe sanctions are certainly appropriate. We believe the most severe sanction is appropriate. There's no way that anyone could, in good conscience, suggest that there's nothing material to be gleaned from an audit report other than what the records they provided shown, Your Honor. And I'm amazed that such a suggestion was even made. We believe that the evidence is clear. I asked Your Honor to go back and take a look at the portions of the testimony that we're being forced to rely upon. I asked the court to go back and look at the affidavits, and you compare the 2 affidavits, and they're not very different, particularly in the aspect that they both prove that this information existed. It just was not, it was improperly maintained, and it failed to be migrated to their permanent system. And that's where we are today, Your Honor. We're left to deal with those failures related to this important information. And for that reason, we ask that the court find spoliation and impose the sanctions up to a finding of spoliation and all of the sanctions that we've proffered for consideration. Thank you.
Thank you, Mr. Benden. You have 60 seconds.
All right, I'll be brief, Your Honor. Thank you. Mr. Davis can be amazed all he wants, but we live in a world where he has to present evidence, and he can't just rely upon his statements in a brief. And all these statements about the granular level of information that should be contained in an audit trail should have been supported by evidence or a citation to a federal regulation that says you have to have this sort of granular detail in an audit trail. We don't have any citation to any regulation that requires that. We don't have any evidence from any expert witness that says, oh, yeah, you should be able to track every little thing everybody does, or when they looked at this specific lab test. It doesn't provide that. And so he might want to believe it should. He might want to believe he would find that, but he's got to present evidence to you, Your Honor, to show how he's really been prejudiced, and he hasn't done that. And so that's all. Thank you.
Your Honor, I just ask you to look at Dr. Arias's affidavit. He's a medical doctor, and it's submitted as evidence in this particular issue. Thank you.
All right, I will take a look at that as well. You have given me a lot to think about. If you have any proposed orders on this issue, please send them to Mr. Burnett by Friday,
Yes.
okay?
Your Honor,
Will do,
may I
Your
ask
Honor.
a
Thank you
question
very
about
much.
that?
Mr.
I'm
Randy?
sorry to interrupt you, Keyshawn. I'm sorry.
Oh, no. Go ahead.
May I ask a question about the orders? Does Your
Yes.
Honor prefer findings of fact and more detailed orders? What's the format you're looking for?
It is helpful to me that you'll be as detailed as possible, but it is whatever you guys want to submit. You know, it helps us get started with our orders, and
Right.
obviously we'll make changes to your orders, but it is helpful
Thank you.
for you to highlight what you want us to look at, if that makes sense.
Thank you.
All right.
Madam Court Reporter, can you submit your contact information in the chat if you don't mind? And thank you, Your Honor, again. Everyone have a wonderful week.
You
Same
all
to
have
you.
a wonderful week. I am going to make Miss Washington the host so
Thank
she
you.
can continue to provide the information that you need. And then you
Evan,
are free to
if-
go when you get it.
Oh, sorry. I'm sorry.
Thank you, Your Honor.
Your Honor.
Evan,
Very
if you'll
good.
get Ms.
Thank you.
Washington's information so we can pay her bill, please.
Will do.
Thanks.
Thank you. It's there.
Miss Washington, are you going to send us a bill? Do you have our contact information?
I have your contact information and I will send you out an invoice.
Great. Thank you so much.
Thank you,
Okay.
Ms.
All
Washington.
right. Bye, everyone.
Bye.
Bye-bye.
Bye-bye. Hold on. Jackie Washington.
Hey.
So good to see you. I'll give you a
Good to
call.
see you.
Is this your contact number here?
It is.
Okay.
But I'll send you all an email. Email with an invoice.
Okay, I will reach out. I'm gonna call you now.
All right. Thank you.
Bye-bye.